and welcome to Season 1, Episode 9 of ARBinBRIEF. My name is Mrinalini Singh, and I'm a founding member of the ARBinBRIEF team. ARBinBRIEF offers a practical video guide on handpicked arbitration issues, and we showcase talented arbitrators. How? Every episode, we have two skilled arbitrators discussing, in an interview format, a specific aspect of an arbitration proceeding. These videos then create a resource for users of arbitration to consult. Over the course of 10 episodes in this first season, we've been moving through the life cycle of an arbitration. And today's episode, episode 9 of 10, will consider issues relating to the costs of an arbitration. These, of course, arise from the start of an arbitration and right past the end as well. So for those of us joining live, this 15-minute recorded interview will be followed by a non-recorded Q&A session. And please do send us your questions anytime using the Q&A function. And now, I'm honored to introduce our arbitrators. Dr. Maria Hauser-Morel is a counsel at 𝗔𝗥𝗕𝗙𝗏, and Dr. Crina Baltag is an associate professor in international arbitration at Stockholm University. So over to you, Maria and Crina, please.
Nadia, a warm welcome to everyone, and particularly to you, Crina. So let's start with the first issue that you have to think of if you contemplate starting an arbitration. How much will it cost? Now, institutions, when determining the cost, use two models in this regard. Cost ad valorem, depending on the amount in dispute, you will have to pay less or more. That's used by, for instance, ICC, SCC, or Delos. Or the cost fixed per hour by hourly rate. Which system, Crina, is more advantageous for the parties, and which system is more advantageous for arbitrators?
Hello to everybody, and thank you, Maria. It is a pleasure to have this discussion with you. And it is correct that we see two models, as you mentioned. We also have an in-between one, mainly promoted by HKIAC, which allows the parties to opt for ad valorem or hourly fees models for arbitrators' fees. And in case they don't reach an agreement on which one, then with default option, in the case of HKIAC, that would be the hourly fee. And before we jump to the advantages, disadvantages, I think it's important to stay a bit at the HKIAC, which offers us very important statistics as they use both models, as I mentioned. And it is striking that in disputes over $100 million, by applying the ad valorem model, arbitrators have been paid 3 times more than in an hourly fee model. So if we look at the advantages, then it would be easier to see that in an ad valorem one, obviously, one advantage is the predictability of costs. For parties, of course, one would know how much funds would be needed in the arbitration. So first of all, to secure the funds to pay the costs, and at the same time to prevent frivolous claims by being able to understand that arbitration may not be so cheap. And for arbitrators, of course, the advantage of ad valorem would be that they might consider accepting or not a particular case. On the hourly rates, and the HKIAC statistics are relevant on this, they do reflect the actual work of the arbitrators. And in particular, I think of the situation where we have a complex case, but of small value. In this particular situation, the hourly rates model would be important. But I think, Maria, you have more input from your ICC experience.
Yes, well, it is true that sometimes these, in small cases, if it's an ad valorem system, it may be very disadvantageous for arbitrators who spend sometimes a lot of time on it. But I would say that this should rather prompt arbitrators in these small cases to conduct case in a cost-efficient manner and to streamline the procedure so as to avoid unnecessary steps, such as, for instance, document production. So I think it should prompt them to act more efficiently. Okay, well, moving forward, Article 14.7 of the Delos rules provides that at any stage prior to the issuance of the award, Delos may adjust the arbitration costs. So we see that arbitration costs fixed in the beginning are not set in stone. And let's imagine a case where in the request for arbitration, claimant quantifies its claims, for instance, a lease for the office, outstanding lease, and then increases this claim at a later stage of the procedure. Will Delos automatically increase the costs following the increase of the amount in dispute?
Well, by the wording of the dispute, I would say not automatically. And I would think that this would be a matter of how big this increase would be. The wording of the provision refers to may. But I think the message here to the parties is that if you do want more predictability in the arbitration, then at the outset, the parties would need to refine, to quantify, and properly assert the quantum of their claims.
Yes, but I would say that that would be the same with the ICC. The increase is not automatic, but we have to remember that institutions, when assessing advances, may consider other elements as well, for instance, complexity of the case. Okay, so let's say that in our case arising out of a lease contract, a respondent makes a counterclaim, and Delos fixes separate advances pursuant to Article 14.2 of Delos rules, meaning each party pays for its own claims. But respondent tells the institution, Delos, I don't have the funds to pay. I can't pay for my claims. Does it mean that the respondent cannot pursue its claims?
You're right, the 14.2 of the Delos rules, but also other institutional arbitration rules, for example, the ICC 37.3, Stockholm, the SEC rules in Article 51.3, allow the institution to fix separate advances on costs. As you said, this means that respondent will pay for advance corresponding to its counterclaim. And if that's not possible, then the counterclaim would be considered as withdrawn. I think this is a double-edged sword to some extent. I see the benefit of the provision in preventing frivolous counterclaims. But at the same time, we have the possibility that without this payment, the institution would prevent the access to justice when a respondent has no funds to pay. And I think it's important, and also my reference to the ICC rules, because as we know, the seat of arbitration is always very important in an arbitration. And we have a case from the Cour de Cassation from France, is the Pirelli case, in the set-aside proceedings against an ICC award, where the court held that the refusal of the arbitral tribunal to consider the counterclaims of a party that failed to pay the advance on costs on the counterclaim may infringe the right of access to a judge and the principle of fair and equal treatment of parties. So it is very important, especially in the broad discussion of the impecuniosity of the parties in arbitration. I do have to stress that in the Pirelli case, the court also made a note that for this decision, it made a difference, the fact that the counterclaim was intrinsically linked to the main claim, and that ICC should have requested claimant to pay for respondent advance on costs. And I see the merits of this reasoning here, because to some extent, but I think, Maria, you have more insight in this, by being so closely linked, if you don't deal with them together, then worse consequences or unwanted consequences will arise from this.
Yes, and that's also the reason why, in particular in cases seated in France, the ICC institution will decide on these issues of separate advances, always in close consultation with the arbitral tribunal. Okay, well, moving on to the issue of the allocation of the costs of arbitration. Let's say that you, as an arbitrator, decide that you do not have jurisdiction to hear the case. Do you still have jurisdiction to allocate the costs?
Yes, I have, but let me give the full answer here. And I think it's fair also from an academic point of view to present to the viewers that there are two competing positions on this question. The first one that allowed me to say, as I would like to say, yes, is the competence principle, which extends although to the issue of costs, irrespective of whether a tribunal has or not jurisdiction to hear the case. The other position, competing to the first one, is that the approach that you don't have a valid arbitration agreement, and that means that you don't have the basis as a tribunal to award costs on an invalid arbitration agreement. But as I said, my preference would be for using the principle of competence. I think not doing this would have unwanted consequences. You don't award the costs. What would be the alternative? Probably going to the courts to recover this cost, which by that time would double. So it's also a matter of dealing efficiently with the dispute brought before the arbitrators. Some arbitration laws, lex arbitri, allow expressly for tribunals to make a decision on the costs in such situation. And one example is the Austrian jurisdiction, the Austrian Code of Civil Procedure.
Yes, and I would say that most ICC tribunals would follow your approach and consider that they have, irrespective of the lack of jurisdiction over the merits, they have jurisdiction to decide on costs. Okay, so you have jurisdiction to decide on costs. You decided that you don't have jurisdiction, so respondent prevails. In allocating the costs, do you apply the rule cost follow the event as the starting principle always?
The answer is depends on the rules, obviously, and the place of arbitration, the seat of arbitration, any mandatory provisions. If we look at the ICC rules, Article 38 doesn't have cost follow the event or the loser pays, but it gives, like other arbitration rules, great discretion to the arbitral tribunal in apportioning the cost between the parties. And I think even more important than this great discretion is the fact that the ICC rules in particular, they in a way alert the tribunal to consider all circumstances that are relevant in doing so, including the extent to which the party has conducted itself in the arbitration in an expeditious, cost-effective manner. And this is a very important provision because, as we know, arbitrators don't have many tools under their belt to maybe keep the parties' behavior in good order. So sanctioning repeated disturbing behavior of a party, I think, is very relevant in having an efficient arbitration. And in this context, I think any behavior of the parties that is not expeditious and cost effective has to be taken into consideration. Now, I mentioned that the place of arbitration is very important. There are jurisdictions where the cost follow the event rule is upheld. One example is the English Arbitration Act in Section 61 that says that the loser pays rule, with two exceptions, one when the parties agree otherwise, and the second exception, which reminds us of the ICC rule, which says the tribunal has to look at the circumstances of the case and consider maybe that it's not appropriate to follow the principle loser pays. Now, for our viewers today, I think it's important to note that some jurisdictions by default are not that familiar with the cost follow the event rule. And coming from a civil law jurisdiction, I can confirm this. But in any case, what is important, and Maria, I know you can add so much on this, whatever decision the tribunal makes in its great discretion allowed by the rules, that decision has to be reasoned, including on the costs.
Absolutely. So for instance, if the tribunal decides to cut the costs due to disruptive behavior, it doesn't suffice to say that party behaved badly, but give concrete examples why the tribunal decided so. Okay, well, moving to the issue of disparity of costs, something that both of us see quite a lot when we act as arbitrators. Let's say that in our case, claimant incurred 100,000 euros in legal cost and respondent 20,000. How do you deal with that as an arbitrator, Crina?
As you said, this happens quite often, and I think proportionality is important. So when you look at the two parties and their legal costs, but I think reasonableness of the costs, something that is overly stated in the arbitration rules in general, has to be kept in mind by any arbitrator. And that means that in this great discretion that is given to the arbitral tribunal, the tribunal has to look at the reasonableness in relation to the dispute at hand. And I think it's fair to say that a dispute that may be not of such great value in terms of the claim, may not be that complex, is very important for one party. And that may justify, for example, hiring a very expensive lawyer to represent the party in the particular situation. It is very interesting because this issue was prompted to be addressed by the ICC Commission report on decision on costs in international arbitration, and I urge everybody to read it. It is very interesting and captures all these very important issues related to costs. The report has noted the situation and also has noted that various jurisdictions accept and give discretion to the tribunal to consider this in the way that is appropriate. All in all, whatever decision is to be made by the tribunal, whether to discount, for example, the 100,000 legal costs, let's say by 15%, the tribunal again has to make a reasoned decision on this issue.
So we give to our viewers a typical legal answer. It depends.
It depends.
It depends. Okay, last question, Crina. We have more and more in-house counsel involved in arbitrations. Can a party recover its internal costs in an arbitration, and if so, on what conditions?
My answer is yes, and it should. And I think it's wonderful what you have mentioned, that we see in-house counsel more and more present in the arbitrations, in-house counsel and any management of the party, because ultimately the arbitration is for the users of arbitration. In general, going back to the arbitration rules, there is great discretion to the tribunal in deciding on what type of costs can be reimbursed in an arbitration. And again, an example from the ICC, but the wording is similar in other arbitration rules. It refers to reasonable, legal, and other costs incurred by the parties for the arbitration. And broadly speaking, the arbitral tribunals, in particular ICC, had no problem in allowing the parties to recover these costs. The problem is, and there is always a but at the end, is that in most of the cases, there is no evidence for the cost incurred by the parties with the in-house counsel. You can put a number on it, but then you need to substantiate your claim in this respect. So one major problem with the in-house counsel cost that is highlighted by arbitral tribunals constantly is that few parties submit or can submit evidence supporting these costs, and the costs have to be rejected because the burden of proof is not met. So I guess an advice to counsel in general, external counsel, to advise the in-house counsel if they work together, for users to take a note of this, that whatever happens, they need to keep a system evidencing this costs.
Definitely, and when I act as arbitrator, I raise this upfront in the arbitration. That way the rules are clear from the beginning. Thank you very much, Crina. Nali.
Thank you very much, Maria.
It was a pleasure.
Thank you very much. Thank you so much, Maria and Crina, for this. And I think that very lively discussion really generates a number of questions. Before we move into our Q&A session, though, we'd like to thank very much our partner organizations Delos, Mundi, and ARBpledge for their support of this initiative. Delos Dispute Resolution is an independent arbitral institution. It was established in 2014, and during the interview, you heard a number of references and questions about the Delos rules. Mundi provides an arbitration research tool for lawyers, and that includes a directory of more than 5,000 arbitrator profiles, along with arbitrator analytics. The ARBpledge establishes concrete and actionable steps to increase the number of women appointed as arbitrators, with the ultimate goal, of course, of full parity. Thank you also very much to ArbitralWomen, Careers in Arbitration, and Rising Arbitrators Initiative for your ongoing promotion, as well as Young Arbitrators Copenhagen and REAL, Racial Equality for Arbitration Lawyers, for supporting this episode. So for the future ARBinBRIEF videos, please follow us on LinkedIn and subscribe to our YouTube channel. You can register for our next episode on www.arbinbrief.com, and we look forward to seeing you there.